This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about how a law firm got its summary judgment reversed in a malpractice case, and why perjury by a witness is a superseding cause of injury. The case called GMG Insurance Agency versus Margolis Edelstein, a decision of the Supreme Court of Delaware on October 8, 2024, reversed the summary judgment in favor of lawyers faced with a claim of professional negligence relating to legal services provided to GMG Insurance Agency. The Margolis Edelstein law firm defended GMG and Howard Wilson, a GMG employee, in a noncompete action brought by Lyons Insurance Agency Incorporated in the Court of Chancery. After GMG failed to prevail fully on its own motion for summary judgment in the Court of Chancery, GMG fired Margolis and at the same time also fired Wilson. On the eve of trial, with GMG represented by new counsel and Wilson represented by separate counsel, Wilson filed an affidavit recanting his prior testimony. Wilson's new sworn statements were drastically inconsistent with his prior testimony and were unfavorable to GMG. GMG, with its defenses obliterated by the perjured statement, settled its part of the litigation for $1.2 million. GMG then sued Margolis. GMG asserted that but for Margolis's negligent representation in the Court of Chancery, GMG would not have been exposed to the consequences of Wilson's 11th-hour change in testimony. The Superior Court granted summary judgment in favor of Margolis, and GMG appealed to the Supreme Court of Delaware. Lyons had sued Wilson and GMG seeking injunctive release and money damages. Lyons claimed that Wilson's employment with GMG breached his non-compete agreement with Lyons, and that GMG aided and abetted that breach and tortiously interfered with the agreement between Lyons and Wilson. GMG had retained Margolis to represent itself and Wilson in the Chancery litigation. Lyons sued Wilson and GMG seeking injunctive relief and money damages. Lyons claimed that Wilson's employment with GMG breached his non-compete agreement with Lyons and that GMG aided and abetted that breach and tortiously interfered with the agreement between Lyons and Wilson. GMG retained Margolis to represent itself and Wilson in the Chancery litigation. The Court of Chancery granted summary judgment in favor of GMG on all counts except for Lyons' tortious interference claim. The court also held that Wilson had breached his non-compete agreement with Lyons. As predicted, Wilson filed an affidavit disavowing and recanting any prior sworn testimony inconsistent with his new affidavit. GMG eventually paid $1.2 million to settle the claims against it in the Chancery litigation. To prevail on a claim of legal malpractice in Delaware, a plaintiff must establish the following elements: 1. The employment of the attorney. 2. The attorney's neglect of a professional obligation. And 3. Resulting loss. Regarding the last element, the plaintiff must demonstrate that the underlying action would have been successful but for the attorney's negligence. The Supreme Court found that the Superior Court erred in 3 ways when it entered summary judgment on behalf of the lawyers. 1, granting summary judgment for Margolis because there are disputes of material fact as to whether Margolis' representation of GMG in the Chancery litigation breached the standard of care owed by Delaware attorneys. 2, failing to address GMG's contention that but for Margolis' alleged negligence, GMG would have prevailed on all claims in the Chancery litigation. And 3, concluding as a matter of law that the Wilson affidavit was a superseding cause that broke the causal chain leading to the settlement of the Chancery litigation. The Court of Chancery granted summary judgment in favor of GMG. This ruling alone evidences the competence and diligent representation of GMG by Margolis prior to termination. GMG also contended that Margolis committed malpractice by simultaneously representing GMG and Wilson in the Chancery litigation, despite a potential conflict of interest. Because the factual record and the reasonable inferences to be drawn from it could support a finding in GMG's favor on its allegations of negligence, the Superior Court concluded the Supreme Court erred in granting summary judgment in favor of Margolis. To break the causal chain and make an intervening cause a superseding one, the intervening act or event itself must have been neither anticipated nor reasonably foreseeable by the original tortfeasor. However, evidence did not show Margolis could reasonably foresee, 20 months before the execution of the Wilson affidavit, that Wilson would perjure himself by changing his prior sworn testimony with the Wilson affidavit. Therefore, the Supreme Court found that the Wilson affidavit was a superseding cause that broke the causal chain leading to the settlement of the Chancery litigation. Margolis is not relieved from liability because it could not foresee the precise event that might lead to or trigger the adverse litigation result. It was sufficient that it could foresee that the GMG remaining as a defendant in the Chancery litigation would lead to an unhappy ending. Therefore, the Supreme Court's erroneous and reversible conclusion that the Wilson affidavit was, as a matter of law, a superseding cause of GMG's damages resulted in the Superior Court's error in granting Margolis Edelstein's motion for summary judgment. Adding to the judgment with a concurring opinion, Chief Justice Seitz noted that Wilson's pre-affidavit testimony by itself was most likely perjury in the Court of Chancery litigation and fraud between the parties to that case, but if GMG then used Wilson's false testimony to prop up its separate legal malpractice action, it qualifies as a fraud on the court, and GMG would be converting fraud between the parties into a fraud on the court, and on remand the Superior Court should decide whether this is the case. If so, GMG's case should be dismissed as a sanction for its misconduct. In my opinion, lawyers, although they try, are neither perfect nor clairvoyant. Lawyers, judges, and every human will err. The trial judges erred, and the plaintiff, GMG, tried to use Wilson's perjury to possibly create a fraud on the court so that it could gain damages from its prior attorneys, and that attempt could, according to the Supreme Court, result in a dismissal of the case for its misconduct. The case remaining is ripe, in my opinion, for an agreed settlement to avoid terminating sanctions. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting and access to the more than 4,900 blog postings. You can also subscribe to these videos on YouTube or on rumble.com. They're free. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.